We're going to go to probate. Probate is the legal process for the administration of an estate. And how many people have ever experienced probate themselves or had a relative involved? So you probably know that this is the legal process where somebody's will or estate planning documents are admitted into the court. And the judge makes the decision on what's going to happen. The first thing that has to happen is that all the debts and taxes have to be paid. The assets are distributed according to the terms of the will, or if there is no will, they're determined according to intestate succession. The proceedings are all public. Now, how many realize that probate starts for real property at a value of $20,000? I used to laugh about this. I used to say, well, if you had a lot in Victorville, you wouldn't have to worry about that. But even in these times, I don't think you can get a lot in Victorville for less than $20,000. Maybe now you can, but so even vacant land that you may not think is a very valuable asset, if it's over $20,000, it's going to be subject to the probate process.
Or overall, what is it, the 100?
$100,000 for all other assets, bank accounts, investment accounts. And how this works, I had a client, a gentleman, 92. His son made sure that his real property, he had a couple of real properties, they were in the trust, no problem. His son didn't know about his bank accounts. So the first time I met with the guy, he was in my office. The second time I met with him, he was in the hospital, but we got all the deeds and everything signed, so the real properties were in the trust. The next thing that happened, the gentleman died. The son came to me very upset. He found out there were 2 bank accounts at the very same bank. They were a total of $105,000. And the bank told the son, we don't care who you are. We don't care that you're the only son. We don't care that you're the only one in the last will and testament, and you're the trustee of the trust. These accounts are $105,000, and you will have to go through the probate court and get a court order before you can have access to these accounts. So the gentleman had to pay $5,000 for probating these accounts, $105,000. Now, some people think that there are advantages to the probate process. And I can think of one situation where there's a big advantage, and this is if the family doesn't get along. The family may have sons and daughters or other members that are very litigious and don't like each other, and they want to sue each other. And so in those situations, it may be very advantageous to just start out in the probate court and have the court supervise, because these people may never agree to settle anything outside of the court anyway. Another advantage is that you have the court completely in charge. So if you think that your sons or daughters or whoever your executor is going to be are not trustworthy, maybe they're spendthrift, maybe they'd like to borrow from the estate and not share it with their brother and sister, it may be a very good idea to have court supervision so the court can make sure everything goes to whom you want it. This gentleman asked, what if your sons and daughters don't get along, you have everything in a trust, and you're afraid they're not going to agree to the provisions? So you put a clause in, if they try to contest the trust, they get nothing. So that's a good question, and there are two answers to that. First of all, you have to have the up-to-date no contest clause that was just changed by California law January 1st, 2010. And there are certain new magic words you have to make in the no contest clause to make it enforceable. If you don't have the new magic words, not enforceable. Second point is, who is going to be your trustee? And so you need to make sure that you have an independent trustee, and this may be where somebody like Peter Coates comes in. You have an independent trustee that is not one of the family members and can make sure that the terms of the trust are followed and the provisions for each child.
I love dysfunctional families.
The biggest disadvantages to probate. One of the biggest ones is that it's completely public. And I think we have a slide in here that shows it. It's a completely public situation. And so as we explained with Mickey Rooney and Groucho Marx, those were living conservatorships. When a person dies and they have a will or they have a trust administration or something that ends up in court, everything is public. So either with a will guarantees probate, or if you have no plan, that guarantees probate. And your assets are all listed. There's an inventory, and it's part of the court file. And so your neighbors could run down to the court and find out how much you're worth and what your assets are. Worse than that, there may be unscrupulous people out there who want to sell products or try to do fraudulent acts against the beneficiaries, maybe a surviving spouse who is grieving, or adult children who are grieving. And so at the time of this vulnerability, some of these unscrupulous individuals may want to take advantage when the surviving spouse is the most vulnerable.
Just to put a little different light on it, there's a judge here in Orange County Probate Court, Bumgardner, who says he would never do a living trust because it's not public. Okay? He believes that he's seen so much fraud in living trust because it's private that he will not do it. He will only do a will in public. I disagree with that. I agree more with Christine, but there is another side to that. Okay, so public and private, there's a whole issue of disclosure, etc.
So you can take your pick which way you would rather go.
Exactly.
The other thing is time, and I have seen some estates that take 5 years or more, which is very sad. I had one case where there were 6 siblings. And the parents had done wills when they were teenagers. And that was the last time they did a will. And then they had both passed away. The 6 kids were in their 50s to 60s. There was 1 daughter and 5 sons. And none of them could get along. And it was too bad because they had a nice estate of 1,000 acres. And if they had been able to get along, they could have done something with it and made some money. But they were determined. They were never going to settle. So we had 4 attorneys involved in it, and the judge forced everybody to sign a settlement agreement, but after it was signed, the daughter has refused to fulfill it. The probate took 5 years, and it's been another 6 years, and it's still not over. So that tells you how long probate can go on. The easy ones may be the shortest. I've never had one that was 6 months, but they could be 9 months, probably, if you're lucky. Average is over 2 years. And so that means 2 years before the heirs get the assets. If there's a family business, the court is involved usually in making decisions. And so if you can imagine a family business being run by a judge, it's a disaster waiting to happen. It may cause the business to go down because each time they need to do something, the court-appointed administrator has to go back to the court and get permission. So it's a very unwieldy process. The judge is happy to appoint attorneys for people who don't have them. And so it tends to prolong the situation.
So for time, you have to file, you have to give notice, there's appraisals, there's accountings, and then there's the distribution.
And then there are the fees. So there are equal attorney and executor fees, and they are calculated on the gross estate. So that means before the mortgages are subtracted, before the debts and bills are paid, before all the costs of the final illness are subtracted. Everything is added up, and the attorney and executor fees are paid on the gross.
And so in a typical $1 million estate, the fees run about
$23,000 for the attorney, $23,000 for the executor, which is $46,000.
And that's not counting the court cost yet.
Right. And there may be appraisal fees, and there may be special, what they call extraordinary fees. So if there's real property involved and the lawyer and the real estate agents have to work on selling the property, they can demand and usually get extraordinary fees.
How many individuals in here have stated that their children can get executor or trustee fees for their work? 1, 2, 3, 4. You may want to talk about this a little bit. You know, I mean, we're talking about probate. The person doesn't have to take those fees if they don't want to. I encourage people to take the fees because nobody appreciates the work that they have done. What is usually the first question a beneficiary asks?
When do I get my money?
This is
my paralegal.
When do I get my money? That's literally the first question.
Somebody recently, the mother passed away, and right away the daughter, is asking her sister, who's the trust, when do I get my check? We don't even have the death certificate yet in this.
Okay, so talk a little bit about trustee fees and executor fees if you're naming one of your children so that your other children will understand that this individual is going to get paid. It creates an immense amount of tension within a family. Okay? Now, by the way, even if you have a living trust, you're still going to incur some legal fees. Hopefully not as much. If you have an outside professional, you're still going to incur some fees. So what is the cost of dying generally? You thought it was free, didn't you? Okay, if you get a cardboard box, that really reduces everything. But if you don't, it's somewhere around 3 to 5% of your net worth. That's an approximate. Okay? So it's not free. There is some cost. There is some liquidity requirements of your estate.
But the advantage here is that the probate costs are going to greatly exceed what it would be if you had a trust. So the advantage of the trust is that it's less time. It can be done privately in the attorney, the administrator, the CPA's office, and it's not subject to public scrutiny or going through those endless court procedures and time-consuming hearings at the courthouse.